My name is James Gondi. I'm the Africa Director of Stop Ecocide International. Just defining ecocide. Ecocide means unlawful or wanton acts committed with the likelihood and knowledge that there is substantial likelihood of severe or either widespread or long-term damage to the environment being caused by those acts. My colleague Jojo Meta will expound more about this form of mass harm to the environment and our attempts to create a legal framework around criminalization of mass harm to the environment. Now, the background of this particular meeting is a focus on the SADC region. We do know that SADC, like other countries in Africa, other regions, are the subject of mass environmental harm through harmful extractive activities, through environmental degradation, illegal logging, and wildlife. While poaching and other types of destruction of wildlife and various forms of pollution. And we do want to reflect on whether there's a possibility to introduce an aspect of environmental crime to tackle some of these aspects of environmental destruction in the SADC region. Now, we know that the SADC region is vast, but there are various SADC protocols that have been established to deal with the environment, and we should look at some of those. The Protocol on Environmental Management and Sustainable Development, and there are other protocols, and to see whether we can focus on sort of a SADC-wide model protocol on environmental crime and use ecocide law as an inspiring force towards that. We could also look at creating national legal mechanisms within individual countries in the SADC region to deal with environmental crime using ecocide as an example. So that is why we are here today, to just interrogate some of those from the point of view of where you work. We have people from the SADC Parliamentary Forum, SADC Lawyers Association, and other very, very influential jurists and activists. And we hope that this will become a fruitful discussion that will develop policy proposals that will go forward formally. Thank you very much. And I will invite Patricia to then welcome Alex.
Thank you very much, James, for this introduction. I would like to introduce our next panelist. His name is Alex Nkolomoni. He is the representative of Stop Ecocide International in the Democratic Republic of Congo. So he's a legal expert, criminologist, lawyer at Kinshasa Gombe Bar, and he's an active member of the Interdisciplinary Research Center on Environmental Law, CRIDE. He's the co-manager of the Green Law firm, and he plays a key role in promoting the concept of ecocide in DRC, particularly within the academic circles. So, Alex, tu peux commencer ta présentation. I believe there is interpretation for everybody, so Alex will be speaking in French. Alex, c'est à toi. Merci.
Merci beaucoup pour la parole, Patricia.
Thank you very much, Patricia, for this introduction. So first of all, I would like to apologize for being in a car. I am on the way to the office, but it is a little bit hard because of the situation in the east of the country, and we have impacts even in Kinshasa in terms of transports, etc. So it is not easy. However, I wanted to be in my office. However, I am stuck in traffic, and we don't know what could be happening in Kinshasa. So, hello, everyone. Thank you to Mr. Gondi for this brief introduction and for organizing this important panel. As you probably know, the DRC is in the middle of a crisis, a major geopolitical crisis, as M23 rebels have besieged the city of Goma in the east of our country, DRC. This is disrupting the entire nation, as I said, on multiple levels, particularly in terms of access to electricity and the internet. You will see that my connection might not be very good, actually. I will therefore be representing Professor Taylor Lubanga, who is very busy with what is happening. So he is the ICC focal point for the head of state, and he is experiencing some connectivity issues at the moment. The Democratic Republic of Congo is pleased to open today's event by expressing its strong support for the initiative, which is being led at the International Criminal Court by the Pacific Ocean states of Vanuatu, Fiji, and Samoa, in order to have ecocide recognized as the fifth international crime in the Rome Statute of the International Criminal Court. I would like to take this opportunity to briefly outline why DRC believes that this initiative is important for all African nations. Our ecosystems, which are home to the second largest tropical forest in the world, recognized as the world's first lung in terms of carbon sequestration, provide us with vital goods and services such as food and medicine, climate regulation, air and water purification, as well as pollination and other cultural services. These essential services are seriously threatened by destructive activities that, in many cases, amount to real crimes against nature. We recognize that this situation will be the same in other African nations as well. The definition of ecocide proposed by the Iceland states as unlawful or arbitrary acts committed with knowledge of the real likelihood that such acts will cause serious, widespread, or long-lasting harm to the environment. So this definition would establish a crucial legal basis. By establishing personal criminal liability for decision makers, it would significantly strengthen accountability and have a real deterrent effect, while simultaneously respecting existing laws and individual nations' right to development. This initiative marks a fundamental paradigm shift. Nature is not an inexhaustible reserve of resources to be exploited without restraint or wisdom. It is time to recognize that we cannot extract indefinitely from a planet with finite resources. And we also need to recognize that destroying nature means compromising the very sustainability of life and the survival of humanity. The Biodiversity COP held in Colombia and due to be continued next month in Italy has challenged us all on the urgency, the necessity, and the opportunity that we are being offered to establish peace with nature. Moreover, the 2050 vision is about bringing humanity to live in harmony with nature. Therefore, Ecocide becomes a crucial step to achieve this, to reverse the trend of biodiversity loss and put nature back on the path to recovery. We welcome this initiative, which we consider an effective solution, as criminal law, by its binding nature, is a powerful tool to address serious environmental damage in times of peace and in times of conflict. DRC believes that this legislation will have a transformative effect on project planning and policymaking. It will incentivize investors and businesses to fully integrate environmental protection into their decision-making processes. by placing nature conservation at the heart of their development strategies. This new legal framework will encourage the responsible and sustainable exploitation of resources in harmony with ecosystems and local communities.
We warmly encourage all African states, therefore, to actively and constructively engage at national, regional, and international levels with these legal developments in the months to come. Today's discussion will, we trust, provide some useful starting point for this engagement. In conclusion, the Democratic Republic of Congo, as a solution country in the face of climate change and biodiversity loss, reaffirms its determination to support this crucial initiative, which constitutes an essential step in guiding the international community towards harmonious coexistence with our planet. Together, we can defend nature against its shameless predators for the sake of current and future generations. Thank you for your attention. Thank you.
Merci, Alex. Thank you very much, Alex. So Alex, as you probably heard, was representing our national, the national focal point of the ICC for the president. So thank you very much for this introduction.
Yes, thank you again from myself, Alex, and thanks to the government of the Democratic Republic of Congo for showing your support and endorsement for Ecocide law at the last Assembly of States Parties that took place at The Hague. And we pledge to continue working with you towards the advancement of Ecocide law and spreading it across other countries in Africa as well. At this point, I'd like to introduce our CEO and co-founder, Jojo Meta, who will give us an outline of Ecocide law, a bit of a context to our discussion, and a bit of history about Ecocide law, where it came from, and what the objectives are. Welcome, Jojo.
Thank you so much, James. Can everybody hear me? Yeah. Okay, wonderful. Distinguished guests and colleagues, it is an honor to be here today. We hope to support the exploration in the SADC context of this fast-growing and important legal initiative, the recognition of ecocide as a serious crime. And now the word ecocide dates back around 50 years. It was first used on the diplomatic stage at the first UN conference on the human environment in 1972. And there have been various attempts to both to define it and to bring it into play at the international level. But those until the last sort of 10 to 15 years, these were not, did not gain a huge amount of traction. And in fact, when the Rome Statute came into force in 1998 and the International Criminal Court opened its doors in 2002, it just was covering war crimes, genocide, and crimes against humanity, despite the fact that in negotiations that were a kind of precursor to that treaty, there was consideration of potentially including a crime that would address severe, widespread, and long-term harm. Now, that concept has been resurrected in recent years, and in particular by the lawyer with whom I co-founded what is now Stop Ecocide International. Her name was Polly Higgins. She's no longer with us. But this conversation has started to move much faster in recent years. And at Stop Ecocide International, we work to support this at the international level, as well as regionally and in national jurisdictions. We work on two levels. We advise and convene, and we inform and connect in the diplomatic context. And at the same time, we track, we report, and we amplify public developments on ecocide law. In other words, we play an important communications role, engaging with multiple sectors in civil society and nurturing the growth of the conversation around this criminal law approach to protection of the environment. And progress on this law has recently been remarkably rapid. So 5 years ago, there were actually no governments publicly discussing ecocide law. And yet, last year, we saw the adoption in the EU of an environmental crime directive that addresses some conduct which is being termed comparable to ecocide, and that is the first time that that term has been used in EU law. And proposals of ecocide law have now been submitted or are progressing and have even been adopted in a number of national parliaments as well, from Belgium, which adopted an ecocide law last year, to Brazil, and from Italy to Peru, where bills of ecocide are being progressed at various stages in national parliaments. And at the global level, as you've heard already, a formal proposal has been made to include ecocide in the list of international crimes in the Rome Statute of the International Criminal Court. And that's a proposal that, as we've heard, is being strongly supported by the Democratic Republic of Congo. So, to take a broad view, why is this particular law gaining so much attention right now? Don't we all have environmental laws already? Well, we do, but they are mostly in the regulatory sphere and can be difficult to monitor and to enforce. And there is little moral stigma attached to breaching regulation. And this is a key point. It often only incurs fines, a slap on the wrist, one might think, and those cannot often compete with profits. Recognizing the worst harms as crimes will make a significant difference. When decision makers know that if they breach regulation and also threaten severe and far more reportable damage, they could be in the territory of personal criminal liability, and this constitutes a genuine deterrent. A crime of ecocide will make foreign investors and extractive corporations accountable, and importantly, make them feel accountable at the highest level. When personal and corporate reputations are at stake, and hence the stock value of the companies in question, it can create real pause for thought. Ecocide law thus presents us with an opportunity to rebalance, restoring power and legal recourse to developing countries rich in resources, among other situations. And I'd like to return to the definition that was just highlighted in the previous presentation, which is the one that has been presented at the International Criminal Court. Ecocide means unlawful or wanton acts committed with knowledge that there's a substantial likelihood of severe and either widespread or long-term damage to the environment being caused by those acts. Now, this definition is very straightforward. It's also strongly based on legal precedent. And the power of it lies in a number of aspects. And most specifically, it doesn't target any particular industry, as this would restrict its applicability. Instead, it addresses the level of harm or hazard. And it also acknowledges that a large proportion of the most harmful practices are already unlawful. They're breaches of regulation or of rights frameworks that are already in existence. It thus recognises and underpins the existing laws in any given jurisdiction without cutting across them. Pertinently, as it's a consequence-focused definition, it respects the right to development while outlawing the most egregiously harmful acts. And this is because it's not about the intrinsic nature of an activity, but how that activity is carried out, where, and in what context. So ecocide law is not intended as a stick to beat local business and workers with. Rather, it is a guardrail against the imposition of genuinely dangerous practices. Any country adopting ecocide law is thus saying, loud and clear, we know how to do things safely. I mean, industrial human societies can never completely avoid damage to the environment. Indeed, there is little human habitation or production that does not create some level of disruption to the living world. What ecocide law will enable us to maintain is a healthy degree of balance in how this is approached. And that's something that has clearly been lost in many parts of the world. I also want to emphasize how useful this definition is as a lens for decision makers. It will spur corporations and governments to address strategic positive change that goes deeper than greenwashing. It's not possible to greenwash with criminal law. Effectively, if you are supporting this law, you are agreeing to be bound by it. Unlike the Paris Agreement or the Global Biodiversity Framework or the Sustainable Development Goals, or important though these are as targets and aims, criminal law is binding and it has consequences. Another aspect to this is that knowledge of the approach of the law will greatly help in prompting decision makers to begin making these assessments now, since it is the period between the moment of awareness of the coming framework and the moment of its adoption that acts by default as a kind of compliance period. After all, criminal law is rightly a tool of justice, but it is ultimately about changing behaviour. It's about putting in place a safety rail for economic activity and steering us towards a world that can work in harmony with the planet and with each other. It will prompt real-world questions. So avoiding, large corporations potentially gaming a system where they can say, well, this activity is prohibited and therefore we're going to reclassify what we're doing as something slightly different, or pushing the lines on how much of a toxin is allowed in a certain context and so on. What this definition does is actually sends those decision makers to a kind of reality check. Is what we're doing or what's happening in our supply chains actually going to create this level, this severe, widespread or long-term level of harm? And therefore it prompts consideration of real-world consequences. And in Africa, as in other natural resource-rich regions of the world, these considerations will be as much human rights ones as they will be environmental ones. The lack of enforceable rules on harms to nature inevitably threatens communities as well, with implications for health, working conditions, access to water, safe homes, safe food production, and many more. Climate vulnerable countries, such as the Pacific Ocean states of Vanuatu, Fiji, and Samoa, have been among the early champions of ecocide law for obvious reasons. Along with many African countries, these island nations have been experiencing the threats of a world that is heating up, very physical threats. Sea level rise, storms, droughts, and floods. These are an existential reality for them, as they are indeed in many parts of Africa. We learned not long ago that while conflict displaces 7 million people each year, environmental refugees number 24 million annually. Ecocide law is also potentially highly relevant to the context of conflict. Ukraine, in particular, has urged the international community to examine the relevance of ecocide law to conflict situations. War, all too frequently, causes ecocidal damage, but this is often sidelined in the understandable focus on immediate harm to humans, to homes, industry, infrastructure. But now we're beginning to understand the interconnectedness of climate impacts, conflict, and ecocide. Environmental harms often reach well beyond the geographical limits of conflict zones and have effects that last well beyond the end of hostilities. Such harms can therefore cause the most devastating long-term impacts. It is therefore important to establish a law that can tackle severe environmental harms whenever and wherever they occur, and for this to be applicable across borders and at the international level. It's significant in this context that a proposal has been made at the ICC, because while the worst harms often take place in Africa, Latin America, other parts of the so-called developing world, the decisions which lead to those harms are often taken in the boardrooms of wealthy northern nations. And as ICC crimes are directed to those in positions of superior responsibility, it is therefore those who are sitting in those boardrooms who will be obliged to apply healthier criteria to their decision-making. And as African nations make up a large proportion of the ICC's Assembly of States parties, this aspect could be of significant interest. There have already been steps taken at the ICC to begin addressing environmental destruction. Already, the chief prosecutor has acknowledged the need to apply international criminal law to situations of grave environmental harm. A policy paper has been drafted on the best use of existing Rome Statute provisions in this regard. The statute as it stands is, as we know, substantively inadequate to address the full range of acts severely threatening nature and climate, in times of peace in particular, as well as conflict, whether or not involving direct harm to humans. However, this policy paper is a decisive step in the right direction, pending development of the dedicated crime of ecocide. And at the same time, conversations continue to grow at national and regional levels. So what we're seeing is a kind of an advancement from both directions, if you like. There's one way of putting it would be to say that, the train has left the station. This is a legal initiative that is clearly manifesting rapidly. So we're seeing a clear direction of travel, and the Democratic Republic of Congo is leading on it in Africa. This is hugely encouraging. And proposals of law on ecocide have been formulated and presented in a number of countries over recent years. And almost all of them have been inspired by or directly based upon the definition that has now been put forward at the ICC, the one that arose from an independent expert panel of lawyers that our foundation convened back in 2021. And we hope that these proposals will serve as inspiration for coordinated national developments, as well as for progress at the global level. And we're, of course, very interested today in particular to see how the SADC countries may be able to develop a coordinated approach to addressing severe and widespread or long-term environmental harm, and thus play an active and leading part in this growing legislative direction towards accountability and the protection of life. I look forward to the rest of the discussion today, and thank you very much for your kind attention.
Thank you very much, Jojo. I think that was a very erudite presentation of the history of ecocide, the contextual approach, and the recent developments in various fora towards the adoption of ecocide law. I would like now to introduce Arnold Tsunga. Arnold Tsunga is a Zimbabwean human rights lawyer with vast experience, having both been the director of the Africa program of the International Commission of Jurists, Africa Judges and Jurists Forum, National Democratic Institute, among other areas. And we did interact with him in a previous Africa-wide call on this particular subject of ecocide law. And I think Arnold can provide us with some ideas about the application of ecocide law in the SADC region, and also give us other innovative input from his vast experience. Welcome on board, Arnold.
Thank you very much, James. And just to confirm that I'm audible enough for you guys and the audience. Good. So, no, thank you. Thank you to you, James, Jojo, for, I think, creating this opportunity of a very important conversation. And thanks to the other resource persons who are going to provide initial views that would allow for a participatory process. And I really appreciate, Jojo, the points that you've raised, and maybe that should be my starting point, that essentially, I'm practicing law in Zimbabwe presently, and I've had a few cases where I've tried through my law firm to contribute to protecting the environment through public interest litigation in cases where there is extensive damage to the environment through extractive mining, riverbed mining, alluvial mining, and degradation of the environment for communities under the guise of development. And then I've also been involved in a few cases, especially where there's been sustained emission of dust to communities where there's cement production at a large scale by Chinese investors working in collaboration with people who are politically exposed in Zimbabwe. But the effect of that over the years is that we have started seeing what is referred to as, the rise of cases of silicosis in an area called Kwekwe in Zimbabwe. And I think those who have been involved in silicosis litigation, that there is a degradation of lung capacity as a result of the dust that accumulates in the lungs, and then it crystallizes into small pieces that then cut the lung tissue and reduce lung capacity to a point where the lungs are no longer able to produce enough oxygen to sustain human life. And in that situation, once you suffer silicosis, which means a sure death sentence. So these Chinese investors, I'm just giving that as an example of Jojo, what you spoke to is competition between profit versus the consequences of non-compliance with preservation of the environment. Those are business decisions that people who are politically exposed, people who come into communities as investors will be looking at to say, what is the value of profit we're likely to make versus the consequences of failing to comply with the local environmental legislation. And I think when the balance is in favor of profit against accountability, then it follows that business people will make a business decision that we have enough possibility to make profit rather than to comply with preservation of the environment. And at that point, the environment is seen not as a legal issue, but as a moral profit when we are in business to make money. And unfortunately, in Africa, because of the nature of economy and extractive based, you find that both local investors and foreign investors will come under the guise of development. When they make their calculations to say, yes, there's local environmental laws, but how much profit can we make if we don't comply? Profit, the requirement to save lives, which then takes me to the second that you raised from you spoke around the offense of ecocide is also an offense against nature. And I think that intersection between the offense against the environment versus the offense against humanity, and that these two so interrelated, so interdependent, intertwined to the point of being inseparable. I think that is also true, because when you look at the example of the case in Kwekwe of silicosis that I'm dealing with, you will find that by not protecting the environment, they've exposed humanity to serious, predictable calamities that are irreversible. And when profits are such that the nature is degraded, but also humanity is degraded, it becomes very clear that the crime against humanity and the crime against nature are basically two sides of the same coin that are mutually reinforcing. And then there's also the point you spoke about, Jojo, Meta, which I completely agree with, and taking the example of Ukraine. But on the other side, I think it's important to add onto that to say ecocide also drives conflict and drives wars, in that there's again a mutual relationship there, that in the areas where there's the greatest conflict, you will find that resources, in particular, extractive resources, are at the center of the conflict, in that they create conditions for conflict. They also drive the conflict, in that those who control resources have a war chest, ammunition, resources that allow them to arm themselves even more and then to be more ferocious in the conflict. And we saw it in Zimbabwe when, we discovered diamonds in an area called Chiadzo, that the desire by those who are in power for diamonds, including the security sector, it created conditions where the ordinary community who find themselves sitting over those natural resources became immediate victims of serious violations, in that when they were trying to benefit from the diamonds, they were then characterized in a narrative of being seen as a threat against national security. And the army was deployed and went into combat with the civilians merely because they're sitting on valuable natural resources. And in that situation, you can see that the natural resources become the driver or the conditions that creates serious and sustained violations. So in this country, Zimbabwe, right now, because of the fact that I started getting more and more involved in environmental cases, I can safely say that the violations of the environment are widespread and systematic enough, and that is no commitment of the apparatus and those who will and exercise governmental power to protect the environment and to also deal with the human rights violations attendant to extractivism. And it also takes me to that point where the governance that and in particular impunity for extractive conduct under great state capacity, governance capacity, the question of civic engagement and civic participation. Because of the fact that when foreign investors working the environment.
Arnold, we seem to be losing you because of bandwidth. Are you able to just switch off your camera to improve the bandwidth that you have?
I think he's actually dropped out of connection. Oh, he's back.
Hello, Arnold.
I'm here now. Should I continue, maybe conclude, or someone has already taken over the space?
No, you can conclude. I think just to improve the bandwidth, you can perhaps switch off your camera.
Okay, perfect.
So,
yeah. So I was saying that the community leaders, community gatekeepers, the people who have a responsibility to govern, who we can call just maybe politically exposed persons for convenience, are the ones who open up geographical spaces where resources are to foreign investors, and they become the domestic partners of foreign investors, but they're involved in an enterprise of essentially the destruction of environment for profit. And so to that extent, when people then begin to be involved even in electoral processes in Africa, the interest of the strong economic player, the strong non-state actor who is absolutely interested in domestic resources, they then become vested, in the local politics, in the local democratic and governance processes, because they want sustainability. So you find that the degradation even of elections, of civic and political participation, of the participation of women in democratic and accountability processes at the local level is then affected because of the crime against nature, the impunity for extractive zip. So I think it's very important from this context that as a region, we begin to look at this wonderful call for sub-regional cooperation to accept that ecocide can be regulated as a crime under the regional protocols, but also under international law. And in Africa, there's also the Malabo Protocol, which is supposed to be complementary to the ICC, where the African countries have established additional crimes that should be seen as crimes, international crimes in the context of Africa. I really think ecocide would perfectly fit within the Malabo Protocol. And then at the SADC level, I think maybe it creates an opportunity to reflect on the SADC tribunal. We did have a judicial institution called the SADC Tribunal that had been established under the SADC protocols that was dissolved as a result of decisions that they made to protect human rights. So the governments of the SADC, driven by our president then, Robert Mugabe, felt that they didn't want the SADC Tribunal to have human rights jurisdiction. And as a result, they then made a decision to disband the SADC and reinstated it without a human rights jurisdiction. So my thinking is that maybe with Ecocide, because of the fact that the population of the SADC is under siege, precisely because of Jojo, what you refer to as the fact that it's a region that is bestowed with huge natural resources and therefore is potentially a global extractive arena. And if it's a global extractive arena, which means there has to be a vested interest on the part of ourselves as civil society, but also our governments to protect the environment, because that's the only way in which they can also protect their own people, which is really part of the responsibility to protect that nation states have. So on that basis, maybe Ecocide could be an entry point to a new conversation on the SADC Tribunal as a sub-regional court that we don't have. We are the only sub-region in Africa that don't have a judicial tribunal that allows for a situation when local remedies are inexistent or inaccessible, that the people can at least have a fallback position under the principle of complementarity. So maybe let me end it there and ask and reserve the opportunity to have further conversation when other colleagues speak. Thank you. Thank you very much, James.
Thank you. Thank you so much, Arnold, for those very incisive and interesting proposals and perspectives. I think we will have an opportunity to discuss those in particular detail when it comes to policy proposals and what we propose can be done at the SADC level, at the regional, sub-regional level, at the national level, and at the international level. At this point, I'd like to introduce my colleague, Thato Gabaitse, who is one of the coordinators for Africa Youth for Ecocide Law, and also from girlplanet.earth, which is a network partner that we work with. Thato will moderate the rest of the session and the other speakers, after which she will provide her own comments, and then we get into discussions and comments. So Thato will introduce the other speakers and moderate those particular next speakers, and then I will come back for the general discussion on the way forward and policy proposals going forward. Welcome, Thato.
Thank you, James. It's been a lovely session so far. I'm looking forward to the next speakers and myself. Our next speaker is Stanley Nyamandini, who is the CEO of the SADC Lawyers Association and also serves as the CEO of the Arbitration Foundation of Southern Africa SADC Division. He's a Pan-African human rights lawyer and development practitioner with vast experience working at the intersection of civil society, business, and government at national, international, and regional level, in particular policy development, harmonization and alignment in human rights, rule of law, democracy, governance, and regional economic integration. He has led regional mediation and regional election observer missions in SADC and played a central role in the drafting and operationalization of key policies, protocols, and sector-specific regulatory frameworks for the SADC region. The floor is yours, Mr. Nyamandini.
Thank you very much, Thato, and thank you very much to the organizers of this very timely and important convening platform. I recognize Jojo, the CEO and co-founder, and definitely James for your efforts in coordinating this particular convention on this very specific topic on how to preserve and arrest the crimes that are ongoing against the climate and humanity. in the context of Africa, and particularly for me, speaking from the Southern African region. And as per introduction, I'm the CEO of the SADC Lawyers Association. And essentially, we are established as the umbrella body for the legal profession or the bar associations in Southern Africa. We were established in 1999, exactly 25 years ago, in Maputo, Mozambique. And our mission that is shared with this platform is to protect and promote human rights and rule of law without fear or favor. And I think we recognize as a necessity that environmental preservation and climate change justice are a human rights issue. Now, we believe in making the law work for the people, in delivering measurable and tangible impact in positive change for the lives of ordinary people in our region. And we know that our environment can only be safest when the weakest citizens are legally and otherwise empowered, protected as well to preserve their livelihood, and which depends on the ecosystems of the earth. And in this regard, SADC-LA has established a regional legal experts technical working group, which is working on climate change and environmental sustainability, chaired by the president of the Law Association of Zambia. This is just by giving a background to how SADC Lawyers Association is engaged in the aspects of environmental sustainability and climate change. And therein, the objectives are to facilitate climate justice, the just energy transition, specific harmonization of laws and the regulatory environment, targeting policies and strategies which make it very hard to implement policies at a regional level. And I think some of the strategies, I see that the SADC Parliamentary Forum is here, per my introduction, has been the development of model laws, specific targeted user guides as advocacy tools here in Southern Africa. We've had special convenings to test viability of these laws, and we've looked at ways in which the lawmaking process here in SADC and perhaps across the African continent can be made more responsive and effective to the target market, so that a lot of the laws that we have do not remain on the shelves gathering dust, but can be operationalized. And I think we've also participated in the setting up of key structures to establish what you call national regional linkages. And these are the structures in which the kind of legal framework we are talking about today need to be couched, can be couched, and so that implementation can actually be realized. And I think we applaud the efforts by Stop Ecocide International, I think at continental and regional level as well, to address this issue of ecocide. I think one specific aspect that I really appreciate about the definition by your, panel of experts on the definition is really making sure that it's not only a positive act, nor only a commission that results in damage, but the specific couching whereby creating conditions that will almost certainly result in damage can be criminalized. And this is very important because a lot of the legal elements that empower members of the legal profession when we conduct litigation clinics in order to establish how we can have public interest litigation in the extractive industry, environmental preservation and sustainability. We find that a lot of the cases cannot be prosecuted or defended beyond certain elements. And I think the couching of the definition and formulation of the crime are very important. And so we look forward to then replicating this at the regional level and the subnational level. And I think that ecocide is one of those laws which really brings about a proactive as opposed to a reactive approach in protecting the earth and our future on it. And I have never understood why we have had legal frameworks that penalize the moment of offense instead of preventing the possibility of destruction. And I think this is the power of the movement that has started here. And the truth of the matter is that unlike other processes or other offenses, environmental degradation per se and offenses against nature are quite quite unforgiving and irreversible, and can spell an end even for the profit-making opportunity for big multinationals. But again, what you realize is it's a greed in the moment that drives people, because no one is concerned about future, generations. So we need to embrace sustainability in the approach to addressing threats to the environment. And we have no choice in this, because again, the environment may be silent, might not react when these severe and massive destructions are being done. But the result is that when the environment reacts, it's quite loud. We see now the climate change, we see the destruction by torrents and storms everywhere, and the changes in the seasons that are affecting food sustainability, the resulting conflict that is there, and the impact is all too real. And it has been stated that the environmental crime is actually growing faster than the global economy in terms of its worth and attacking of the global flow of capital. And this is so devastating in Africa, because natural resources are plentiful, but there is no technological advancements, there is no capacity to harness and turn them into value. So poverty is also very high, and unfortunately this is compounded or juxtaposed against weak governance systems, especially around issues of natural resources. And you realize that there are quite a number of protocols, there are quite a number of very progressive legal frameworks. But as I will outline, these don't speak to each other. The standardization and the harmonization, it's impossible to enforce these in a manner that produces a coherent body of law that will create precedent and conditions that help us to effectively create deterrent to large multinationals. And again, you have the challenge of governance in our context, where some of the institutions that are responsible for ensuring that some of these protocols and local laws are implemented correctly may be compromised, may be under severe political executive pressure. Some people like to refer to the term of judicial capture, but also we've seen recently parliaments that also respond and work in complicity with the executive. And there's nothing particularly wrong about this, as we remind ourselves, but that is precisely why the law and the rule of law were made. And we know that politicians will always want to hog as much power as possible, but we have to engage in wide-ranging advocacy and coalitions with synergies that respond to this. And I think that this is a wonderful and powerful initiative to give us agency to speak with one voice and create those ecosystems that will respond to this. So in the context of the Southern African region, why is it therefore important to have ecocide declared as a crime at the international level? Yes, that's very important, but it is also critical, like this discourse is proposing, to have ecocide recognized as a crime in a coherent protocol, policy, or principles and guidelines, whatever you may like to call them, that are regional and which can be aligned to the regional legal frameworks and harmonized so that there is correct and consistent application and implementation, as well as interpretation by our courts. And I think it's quite clear, it has really come out that the communities that we have do not have any access to the ICC itself. They don't have access to, a knowledge about the international standards. And you look at law enforcement agents like policemen, judges, prosecutors, they do not have knowledge of the advocacy or jurisprudential impact of a crime at a global level, its elements and all of this. And localizing the legal framework is what brings knowledge of the elements of successful prosecution, of successful monitoring, but also awareness of the rights of communities that are living in impacted areas. I think we heard Arnold talking about the issues around silicosis in Kwekwe, and many other issues that arise. So building a regional framework will foster the alignment to local and domestic regulatory frameworks that become a living tool for protection of the environment that can be used by these marginalized and affected communities, individuals, and also by civic society, which is providing agency and voice for these people. And with these in place, I think we can start to see some progress. And in criminalizing ecocide at the continental or regional level, with probably strategies that are tailored for local dynamics, needs, and capacities, we can begin to see a difference, and I think deterrence in the whole value process of extractivism, from negotiation of the contracts, from the extraction, and from the the conditions before and after extraction for compliance, and then after extraction for rehabilitation and all of this, which not normally many people pay attention for. So we really berate the fact that current legal mechanisms to address environmental harm are often weak, fragmented, and insufficient to deter environmentally harmful practices. And insufficient laws do not deter crimes against the environment, leading to lack of developed or consistent and effective enforcement mechanism. So I think in this context, let me maybe, before I go to my conclusion, just look at the policy development aspects of SADC and how SADC's legal framework will facilitate, welcome, and promote the establishment of ecocide as a crime, and the establishment of a regional treaty or protocol. I think the Bible for us in the SADC region is the SADC Treaty, as amended in 2000. The consolidated text thereof provides pathways to enacting laws. And one of the key objectives that is linked to our activity here is Article 5G, which says that the SADC Treaty states that states shall achieve sustainable utilization of natural resources and effective protection of the environment. And still under the same article, there is a mandate to harmonize political and socio-economic policies and plans of member states. These are very critical objectives that create our foundation to propose the development of this SADC-wide protocol. And at Article 12, it designates as a pillar of regional cooperation and development the pillar of food, agriculture, natural resources, and environment. This is a core area of integration among 6 existing integrations. I think the other ones are infrastructure, energy, mining, and all of those other things. But so this is the context in which we can certainly say the SADC Treaty, which picks up from the African Charter and many values that pronounce the mandates of African governments, gives us a platform. And I think the SADC itself has got an integrated strategy to prevent and combat transnational organized crime. The SADC Protocol on Environmental Management for Sustainable Development was mentioned. I think there's a protocol on forestry and so many pillars around environmental preservation. I think if you delve deeper into the region, there's some work and reports here, yes, on mechanisms for implementing multilateral environmental agreements under the UN, and so many more things that are in the works. But I think it's very important to bring this to a head in a coherent, systemic protocol that will enable us to monitor, to enforce, and to hold accountable. I think this is the most important outcome of any protocol, to be capable of, to enable us to hold accountable any agents or any institutions, individuals, or organizations that violate environmental standards. And Arnold has spoken about the role of the courts and enforcement mechanisms here in Southern Africa. And let me talk a bit on the role of the courts in that. it is very critical, I think, alongside establishing these legal frameworks, especially in the SADC context, to advocate for ratification and use of the protocols and policies that are in place. So particularly respect for the Rome Statute itself and the ICC. I think the record in Africa shows that there's an attempt to acutely reduce platforms of accountability by governments, sadly. I think the example of the Zambian nation about 2-3 years ago got into a referendum on whether or not they should pull out of the Rome Statute. South Africa, around the same issue, also attempted to pull out of the Rome Statute. And the essence of the Malabo Protocol, by way of just explaining, is that it establishes an African criminal court. Now, this Malabo Protocol, very great, very ambitious, and can be also very important, but is also established as an African agency and alternative to the International Criminal Court in terms of political parlance, discourse, and attitude. Now, how do we marry these and ensure that there is some form of continuity from national, regional, continental to global accountability? And again, you have the counter side of the efforts that we are mounting here, speaking about China, the USA, India, who perhaps are contributing most to harm to the environment, not being parties to the ICC. And then in SADC, I think when you look at the SADC tribunal, one thing to add is to what Arnold said, is the fact that the tribunal right now is actually under reform as we speak. The SADC is actually consulting parliaments and stakeholders and coming up with a new protocol to replace the one that disbanded the jurisdiction of the tribunal to actually have oversight and be able to adjudicate on matters of human rights violations where local remedies have been violated or have been exhausted rather. So we need as a coalition of interested organizations to be present in this discourse. It's very urgent, because otherwise a few months from now, a new and improved protocol will come up and it will not have the requisite elements for a minimum human rights apex regional tribunal. And the Malabo Protocol itself, only 15 out of 35 countries have, out of 54 or possible 55 countries have ratified it. And you need 35 countries to actually bring it into effect. So this means that it hangs in balance. The court itself has not come into being. And so we don't yet have an African mechanism for criminalization and for prosecution of criminals and crimes against the environment. And again, the technical issue here is that multinationals and institutions or individuals powerful enough to destroy the environment on a severe and large scale, these are very key requirements for an international crime, can abuse the local court system and evade accountability through lack of jurisdiction. If you are hidden in many shell companies and the parent company is in a country that is not a party to the Rome Statute, then we are having challenges. And if a multinational or a community is acting in complicity with politicians, again, we are having challenges. So regional tribunals are needed to counter such loopholes and create an ecosystem that enables our wonderful protocols and laws to be implemented. And in the local context, it is not extreme to think about specialized courts, I think, for environmental crimes. I can't think of a crime that is more urgent and evasive of human rights and human existence and human life than, crime against the environment at a massive and severe scale, which is irreversible and will affect the very existence of our planet. So I think this can also be accompanied even by special investigations unit, because our ordinary prosecutors use, yes, principles of law, of criminal law, but special knowledge of issues around the environment is very important. Now, as I go to conclude, let me just speak to what have we been doing in the SADC region that provides practical and administrative agency for the implementation of laws, protocols, and regulatory frameworks that enforce, human rights and criminalize violations against the environment and climate. The important issue is that climate change and environmental protection is a cross-cutting theme. It's what we need to realize. It goes into areas of public finance management, agriculture, industrial zones, local authority laws, administration of homes, transport infrastructure. Everywhere opportunities arise to degrade the environment. That also means opportunities arise to protect the environment. And in that regard, I think the rights guiding principles and value on climate change that we've seen being developed by countries like Zimbabwe, for instance, prescribe what helps to mainstream climate change into social, economic development plans, programs, projects, and budgets. And I think it's important that civic society, governments, and ministries that are responsible, line ministries that are responsible, start to be engaged so that they are aware of this definition of ecocide. And I think the legal elements are excellent and expertly crafted, and it will help even before the escalation of the crime to a national crime as a fifth class of crime under the ICC is complete. It will help to make sure that there is already alignment started and that the implementation is actually in line with the actual objectives of holding accountable those who violate. And in the context of SADC, one of the key issues that we did find out from a study, and I think the UNDP also found out this from a study across the African continent, top to bottom development of laws and protocols has been a challenge. Key stakeholders are not consulted. I think it's only a small panel of experts or one expert who's given a consultancy, develops a very well-sounding protocol, and it gathers dust. And the nature of the AU of SADC is that these are elected officials. They've got 5-year lifelines. Unless they come from a jurisdiction where it's possible to continue practicing as a head of state beyond the constitutionally stipulated term limit, but mostly they go away and the politicians go away with them, and there's no knowledge amongst the implementers, those expected to implement the law, about the law. So again, they need to be engaged. And we've always found that insufficient formulation of crimes and inadequate definitions leads to deficits in awareness raising, enforcement, and implementation. We really, really hope to see litigation skills building through litigation clinics, strategic litigation identification, public interest litigation has been raised, the issue of legal aid, and the widely happening issue of slap suits against environmental human rights defenders and NGOs and advocates for environmental protection, as well as community advocates, is happening because, again, there are resources on the part of offenders to frustrate those who are trying to arrest or hold them accountable. And I think it's important to create platforms for discussions with our judiciary in colloquia, platforms for building the capacity of our prosecution, legal empowerment of communities through pro bono. I think one of the key issues when you speak to the African context is that even when people know their rights, it's not really possible or affordable to access justice. And I think these are some of the issues that we need to then look at changing. Here in SADC, you have the agenda setting platforms, which we must make sure are known before or when we introduce this discourse and the legal frameworks that are already existing and proposed, and those that are to come. So, for instance, the SADC national committees, these are the national agenda setting spaces. A lot of our CSOs go to the SADC summit where all the SADC heads of state meet. They picket, they've got placards, they have their own parallel summit. They denounce environmental degradation, they denounce human rights violations, emissions, and they say no to, multinationals coming to rape our economies, as it were. But the essence is that if only we take time to submit and participate in the SADC National Committee, which is the structure that actually implements and drives the regional agenda, only can this issue be on the agenda and be formally considered. So again, we run rounds around our own advocacy, and there's also what is called the SADC Non-State Actors Forum. I know that part of the people who are working with your coalition or with your organization are people that are very active in formalizing the engagement between SADC and non-state actors. I think, yes, it's at different stages of development. There's so much that still needs to be done, but it's a positive development. And again, I spoke about capacity building in those areas of drafting and developing and negotiating these legal frameworks and contracts that lead to extraction and exploration of natural resources in the African context, so that there is some form of watertight provisions to ensure that there is no violations going forward. And I think a lot of lawyers that I've witnessed when we do training do not have this capacity, do not know how to stand against your big 5 global law firms who bring a team of 24 lawyers just to argue one provision. And this really is what destroys or allows big multinationals to get away with violations. So again, these are just some of the key elements that I highlight to show that the work that we have set out to do in this platform that you are leading is situated on an axis of multiple frontiers that must be made to speak to each other for us to have success. I thank you very much, moderator, and wish the rest of the conversation a robust, fruitful, and constructive outcome.
Thank you very much, Mr. Nyamandini, for sharing the key policies and regulatory frameworks and linkages on how we can, as civil society, we can engage on a national level, and the challenges that we face and opportunities for engagement further. Our next speaker is Kirsten Younes, who's a prominent environmental attorney and the executive director of All Rise, a nonprofit organization focused on climate and environmental justice based in South Africa. Throughout her career, she has specialized in various aspects of environmental law, including environmental justice, wildlife protection, mining legislation. Her commitment to environmental activism began in her childhood, leading her to engage in significant pro bono work, notably against coal mining operations in Zululand. And she has been involved in high-profile cases that address the intersection of environmental rights with human rights, cultural heritage, and land rights. The floor is yours, Ms. Younes.
Thank you, Tata. Thank you, everybody who's spoken before me. The only person I know in person is Arnold, so it's always lovely to work with Arnold, and it's been a very interesting and informative morning so far. Wow. I think I should just settle in here because I could talk all morning on the subjects that we've been discussing, and because I've been an environmental lawyer for over 20 years. But All Rise has been in practice since 2019. And the work that we've been involved in is, without a shadow of a doubt, ecocide. It just hasn't been termed that until until we're talking about it now. It's without doubt ecocide. And it's ecocide. I've seen ecocide in our land, on the land-based activities, but I've also seen ecocide in what's happening in our marine environment, and I think it's important that we don't actually forget that. So let me just tell you a little bit about the things that we're involved in and how there's, without a shadow of a doubt, a need for ecocide to be a criminal term. We work a lot with mining, unfortunately, inevitably wide-scale mass destruction of the environment often comes as a result of mining. We have a lot of work done. We do a lot of work in KwaZulu-Natal in communities where there's huge areas of open cast coal mining, but also up in Limpopo province where there's a proposed megacity or industrial metallurgical hub that is going to be fueled by coal. It's a power station, an iron ore smelter, and whole industrial zone that is going to destroy 8,000 hectares of indigenous bush, including 600,000 protected trees. That is the application, the permit that has been made to the department for the removal of protected trees is over 600,000, including baobabs, leadwoods, shepherd wood trees. If that's not ecocide, I don't know what is. And we also work in Mozambique, also unfortunately with mining, a lot of mineral, the heavy sands mining to extract minerals from the soil, and that's all on the coastal region of Bazaruto and Inhambane. Also, large-scale ecocide and destruction happening there. And as in lawyers, we've been faced with, as Stanley mentioned, the SLAP suits that environmental lawyers have faced and often face. We have not in form of SLAP as such, which is a defamation law case generally, but we have it with interlocutory applications. So, for example, in one of our big matters in KwaZulu-Natal, where we're acting on behalf of a community that is trying to stop open cast coal mining, I was sued in my personal capacity to remove me from the case, and I've been reported to the Legal Practice Council. We've been defamed on social media. I've been defamed personally on social media. So there are those things that we always have to deal with, and that's why, just to digress slightly, the regional concept of in the SADC region where we could all work together is hugely positive and certainly would be supported by us. So we have done a lot of litigation, not all of it successful. And I think it's important to know upfront the problems that will happen with I foresee with the crime, the possibility of ecocide as a criminal prosecution, a crime as such, is that immediately my first thing is when does it become ecocide? What is the scale? What do we have to prove for enough destruction to be taking place for it to qualify? There are major challenges in South Africa with compliance and environmental management in general, in spite of the laws that we have in place to help us. The laws are great. It's the implementation that is the problem. It's the monitoring, it's the enforcement that is the problem. It's the lack of funding. It's the time that it takes to get things into court, through court. It's the intimidation. It's the fact that inevitably we're fighting big industry with a lot of money, deep pockets, and a huge vested interest to keep fighting. So tactics that we've seen is that when we file our pleadings, the answering papers, the replying papers are literally thousands and thousands and thousands and thousands of papers that we get buried in, and it takes weeks to get through, that the judge doesn't even want to read because it's just too much. And in fact, the opposing attorneys don't even actually refer to. But it just drowns everything and everyone in paperwork. Prosecution of environmental crimes in South Africa is even more difficult, and where the few that have been prosecuted, the sentences are poor. But it's not to say that it's not needed. So there's absolutely no question that, and I loved what Jojo said about the fact that it's taken far more seriously. There's more weight to being charged with ecocide or found guilty of ecocide. The question is where in South Africa or in Mozambique or in any of the SADC countries, where Where will it begin and end? And all of our cases that we've managed to get into court and heard, where we're not drowned in paper, when we are drowned in paper, the argument is always about economy, the economics. It's about jobs. It's about keeping businesses going. And it's almost as if, the environment is second to that, but even our clients. So our clients, for example, are communities living on the edge of open-cast coal mines. We've seen in the work that we've done that large-scale destruction of the environment destroys ecosystems. It destroys the integrity of the ecosystems. What it inevitably does is destroys any form of climate resilience that ecosystem could have had, even in the face of the climate crisis. So what potential climate resilience that ecosystem had is now effectively destroyed by the mining, for example, but also people's climate resilience. So the ability to live off your land, sustainably farm, produce your own food, draw your own water from streams and rivers that are not dry and not polluted, that's destroyed. It does create community conflict. As soon as the environment is destroyed, community conflict comes in. That we've already spoken about. But what we've also noticed, which hasn't been discussed and which has to be put on the table when ecocide is as a concept and a definition is referred to, is that we've seen that the destruction of the environment causes massive psychological stress, and it's ongoing. So it's a chronic stress. We've had a psychologist do research into both communities that have ongoing environmental harm and communities that have the potential of environmental destruction through mining that will be coming to their areas, for example. And the results are absolutely appalling. The psychological stress caused by degradation of your environment in which you live, the loss of cultural practices, the loss of land-based livelihoods, causes a massive collective trauma. And a lot of it is caused by institutional betrayal. So that means the institutions that are charged with taking care of you, so the government that you can report to and they're supposed to do something to protect you, are not there for you. So it's an institutional betrayal, a collective trauma, and we're seeing large and widespread cases of depression, PTSD, and suicidality. So my point is that ecocide is definitely and obviously an environmental issue. But I've learned over 20 years, and specifically in the last 10 years, that in the human destruction that comes with the destruction of the environment is massive as well. And it's vital to always connect the two. So I haven't even spoken about the wildlife aspects. It seemed to me that our conversations so far have been so involved with the human environment connection today that I think I just keep that, what I'm saying, focused on that for now. So I'm looking forward to having more discussion and questions and answers. Thank you very much.
Thank you very much, Ms. Younes, for highlighting the local struggles and aligning them with international human rights frameworks. I believe many of us resonate truly with what you have just shared. And I believe by the end of this session, we'd have really unpacked more and developed a policy or engagement on how we can proceed further. Our next speaker is Ms. Rachel Mondilo. She's a lawyer and parliamentary expert with experience in legislative drafting. public policy formulation, parliamentary procedure, and regulatory affairs. She works as the coordinator of the CVF Global Parliamentary Group, a network of legislators from climate vulnerable countries at the Global Center on Adaptation. In this role, she supports the development and implementation of climate adaptation policies and initiatives, facilitates the exchange of best practices and lessons learned, and foster partnerships and collaborations amongst parliamentarians, governments, civil society, and international organizations. The floor is yours, Ms. Mundila.
Thank you very much, Tato, for that illustrious introduction. Although the reference was made to my previous role, I currently actually serve as program manager for the Food, Agriculture, Natural Resources and Climate Action Committee at the SADC Parliamentary Forum. So the reference was to my previous role. But on that note, let me begin by expressing my gratitude to the hosts for organizing this critical and timely session on the development of a regional protocol on environmental crime in the SADC region. Of course, as we address this pressing issue, I think that to echo many of these speakers before me, it is, of course, imperative that we reflect on the profound vulnerability of Africa and the SADC region to the impacts of climate change and environmental degradation. So, of course, the consequences of our inaction as a region are real, they are imminent, and they are far-reaching, and they will lead to further entrenching the existing vulnerabilities that we see in our communities. So there is, of course, an increasing imperative on decision makers to collectively push the needle forward to ensure that there is environmental justice. The rampant disregard for environmental laws and the growing evidence of ecological harm underscores the need for innovative approaches such as through the recognition of Ecocide. Ecocide, as it has been stated by the speakers before me, is of course a relatively new concept, particularly in the African context and for the SADC region. But the progress made in Latin America and Europe, as was shared by Jojo, of course provides valuable lessons and best practices that we can leverage on as a region and as a continent. And I think their successes in integrating Ecocide into legal frameworks highlights the potential of criminal law as a powerful deterrent, offering additional guardrails against environmental harm. So as Jojo again illustrated, the growing traction in the fight against Ecocide has been advanced both at the international level and at various global forums. And this, of course, signals the growing consensus on the need to include Ecocide within the scope of international crimes. And I think SADC member states should be encouraged to actively engage in these conversations, advocating for a framework that addresses the region's unique vulnerabilities while also contributing to the global effort to establish Ecocide as a recognized crime. So the SADC Parliamentary Forum was established in 1997, and it plays a pivotal role in advancing this agenda. As a regional body for SADC parliaments, the forum facilitates interparliamentary cooperation and diplomacy on issues of regional concern. And our core priorities include democratization, governance, human rights, human social development, gender equality, women's advancement, youth development, trade industry, finance and investment, and of course the committee which I coordinate, which is on food, agriculture, natural resource governance, and climate action. And this committee is, of course, the committee under which today's discussion falls, of course, recognizing the cross-cutting nature of the issue at hand. And I think it is through this program wherein the opportunity lies to integrate Ecocide into the broader framework of climate action, by leveraging parliamentary engagement to drive policy change and legislative development. So the SADC Parliamentary Forum, as I indicated, works through those programs on those specific thematic areas. And these programs are, they anchor each standing committee of the forum. And in addition, they are deliberately aligned to the directorates of the sectors of the SADC Secretariat, which Stanley spoke about extensively. And this is, of course, this alignment is to ensure that the areas that we focus on are responsive to the needs and the priorities of the region. It is important to note here that since July of 2024, 12 member states have signed an agreement to amend the SADC Treaty to recognize SADC Parliament as one of the SADC institutions. So essentially what this means is that the SADC Parliamentary Forum will become an institution of SADC. And with the agreement coming into force, member states have now been tasked to submit comments to the Secretariat on the draft protocol, which seeks to operationalize the SADC Parliament. The SADC Parliamentary Forum, as it stands, has a significant role to play in advancing the national and regional integration agenda to address environmental crimes. And the SADC region as a bloc, of course, can, of course, deter criminal environmental crime by strengthening regional cooperation, harmonizing legal frameworks, and enhancing enforcement mechanisms. And to address these efforts, there's a need to, of course, prioritize, as I've indicated, the harmonization of regional legal frameworks by aligning national laws on environmental protection and criminal penalties to close the regulatory gaps that can be exploited by international corporations. And of course, there's also equally a need to enhance law enforcement and judicial capacity. And I think this can be achieved by some of the avenues that were advanced by some of the previous speakers through the revival of the SADC Tribunal, ensuring that there's a specialized regional enforcement unit or task force that are dedicated to combating environmental crime. Of course, ultimately, law is not self-effectuating, and it requires external enforcement mechanisms to ensure that the legislative measures in place are implemented and adhered to. In addition, of course, we should also focus on ensuring that there's cross-border collaboration to combat transboundary environmental crimes. And as a region, there's a need to ensure that we facilitate information sharing, intelligence gathering, and coordinated operations amongst member states to dismantle environmental crime. In addition, of course, there's the key component, and I know Stanley spoke about this extensively, around strengthening community involvement, ensuring that we engage local communities in the conservation and crime prevention efforts. And the regional bodies can, of course, support community-based participation in environmental crimes, and to ensure that they are incentivized to ensure that they advance sustainable practices, and also to strengthen surveillance efforts. I think both Stanley and Arnold also spoke to the need to ensure that the regulatory frameworks are, of course, responsive to the needs of communities, and to equally guard against the top-to-bottom approach to legal norm making. And I think I just wanted to add here that public engagement is a key priority of the SADC Parliamentary Forum, and we continue to develop and grow the mechanisms to ensure that we are able to engage with members of the public. To respond to these core areas, as I've highlighted, I think the SADC Parliamentary Forum is mandated to develop model laws on issues that are deemed pertinent for the development objectives of the region. And these model laws are, of course, anchored in regional, continental, and international commitments that were mentioned earlier, such as, and for example, a regional protocol on environmental crime in Southern Africa will will serve as an anchor to the establishment of the model law. And what the model law essentially seeks to do is to provide guidance for the domestication of these regional, continental, and international instruments. I think for many of our jurisdictions, again, international standards instruments are not, again, self-effectuating. It requires some domestication process in order to give effect to it. And what the model laws essentially seek to do is to provide a gold standard and an important persuasive measure that is aimed at persuading member states to embark on legislative reforms to give effect to these international and regional obligations and commitments. Of course, the model laws that the SADC Parliamentary Forum develops are adopted at the forum level. However, domestication is done at the national level, and as I've indicated, this is dependent on the national legislative or executive action, and it will evolve according to the requirements and complexities of the national constitutional requirements and processes, which again may vary amongst member states. So it's not a one-shoe-fits-all approach, but rather it provides a gold standard or a benchmark which member states can draw from and can advance. And of course, once approved or adopted at the forum level, it doesn't end there. We don't just approve the model laws there. We have post-adoption strategies in place that are guided by what we term the Regional Parliamentary Model Laws Oversight Committee, which is tasked with monitoring and evaluating the domestication efforts of a SADC model law on environmental crime. So ultimately, the impetus for domestication of such a model law at a national level must be driven by parliaments themselves, and national legislatures may use various methods for incorporating these international obligations. So reflecting on the principles of their content in the national law, setting out the text in national law, either in full or in part, and of course giving effect to these supranational instruments. And again, we just to reiterate that we do not necessarily advocate for wholesale adoption of a model law, although that would be ideal. The model laws rather serve again as a gold standard. And what is key in the development of model laws, I think, and that we need to note are two very important concepts around the attitude or the disposition that those that are engaged in the processes for developing such a law may have towards its development, as well as the ability, of course, for legislators, parliamentarians to engage in the process for developing such a law. So it speaks to their ability to engage and also their attitude towards developing such a standard. And these two nouns, attitude and ability, speaks to the political will of the decision makers. I think Stanley also spoke extensively around this, and of course the power relations of political actors that participate in the process of developing legal norms, speaking towards parliaments that work in complicity with the executive. And on the ability side, of course, we're speaking about the capacity of lawmakers to exercise their oversight role to facilitate the domestication and implementation processes. So as a parliamentary forum, we encourage networks such as Stop Ecocide and the networks that are in this call to continue to facilitate the capacity development efforts amongst lawmakers, to encourage the development of knowledge tools, and also to provide platforms for peer learning amongst parliamentarians from within the region and beyond, to ensure that we are able to respond to this pressing challenge. On that note, we look forward to continuing this discussion with the various entities represented here, and we hope to ensure that there is a consistent legislative response from parliamentarians to environmental crimes. Thank you for the opportunity once again, and I submit.
Thank you very much, Rachel. I think those are very important and strategic interventions that you proposed in terms of welcoming some kind of SADC model law on environmental crime and giving us the nuances of how that can be pursued. I think what I will do is adopt this particular forum as a working group on the promotion of environmental crime and ecocide law as part of the SADC framework, and we can start at some point by strategizing on WhatsApp. I think we should then, because we've had very many positive interventions, I'll ask Thato to just provide her brief interventions for 5 minutes, after which I'd just like to go around and every participant can just mention 2 key interventions that can be proposed to advance environmental crime in the SADC region. 2 key strategies that they can commit to pursuing in the individual and collective capacities to advance this discourse within SADC, so that at some point we can have some model law. In the European Union, we did have European Crimes Directive, and they talked about environmental crime, and then they talked about crimes comparable to ecocide. So perhaps that's an approach we could use in the SADC region. So before we go into just those 2 quick interventions per person, Thato, please give us some brief interventions from your end.
Thank you so much, James. I'm pleased to learn from all the prominent and well-experienced speakers on the recognition of ecocide as a crime, which will provide guidance, as Ms. Mundilo has shared, on the gold standards that are in place, which will provide guidance on member states and as civil society to demand transparency, accountability, and on progress and engagement with communities and such. In my capacity as the Southern Africa focal point, I had the privilege of engaging with indigenous communities and in Botswana, and they developed a position statement where we see that rights continuously undermined as guardians of the ecosystems, and they noted the need for recognition of their rights, inclusion of traditional knowledge and genetic resources, land and resource rights, free, prior, and informed consent, participation, and representation. And as the previous speakers had previously mentioned, the need for capacity development and support. And I believe from the working group, as you've mentioned, James, that we will lean onto that. And I'm looking forward very much to seeing the progress on that, because as we know that the challenges we face in terms of prosecution and existing legal frameworks where the existing laws fail to adequately protect indigenous rights or deter environmental crimes. And there's also that resistance from state and corporate interest as we engage with them and demand these things, because there really isn't anything to hold on to. Thank you so much for this opportunity. I'm looking forward to the collaborations and advocacy efforts to strengthen community resilience. Back to you, James.
Thank you very much. And I think I would like to proceed in this order. Arnold, and then Stanley, and then Kirsten and Rachel. Just 2 quick interventions that you would make from the position you sit to advance the cause of ecocide law in the SADC region, and then we'll make that the basis of a working group that will convene on WhatsApp, and then then decide from there how to make our first a few interventions going forward so that we can turn this from a discussion into action.
Yeah.
Arnold.
No, thanks a lot, James. I think what I can do, which is within my sphere of control and influence, and to avoid over-promising and under-delivering, is that because I've got a very good relationship with some of the key stakeholders in the justice delivery chain, the Judicial Service Commission, the National Prosecuting Authority, and then the Permanent Secretary in the Ministry of Justice. And then maybe the Law Society, which is a mutual area between Stanley and myself. What I could do is to increase the awareness of these key stakeholders that the public interest litigation that we are doing is not enough to protect our environment and to protect the most vulnerable of our communities. And that, at least as a result of the litigation that we've done, it is clear that there is need for a greater policy intervention, including, regional cooperation. When I was speaking with the prosecution authorities last week, they were lamenting rather the gap at the mutual, they're talking about mutual legal assistance between the different SADC countries, and the fact that for serious crime and money laundering, illicit financial flows, which all reinforced or strengthened in an environment where there's impunity for ecocide. I think there could be room there to increase the awareness and to look at whether getting into some form of protocol would be this way in provide cover to protect the world relations, especially where business is involved. Because, when business is involved and they make profits, sometimes they begin to control even the political. I know Stanley spoke about politicians, but politicians sometimes are just instruments of non-state actors who are very powerful. And the power these non-state actors have is because of their impunity in degrading the environment for profit. And therefore, I think it's important. I can commit to at least have a conversation and then share with our colleagues the outcomes of that conversation with the key stakeholders. Over.
Thank you very much, Arnold. That sounds very promising. I think we'll move quickly to, I'm just trying to get my video on. We'll move quickly to Stanley. If Stanley is still with us, if he's not, we understand because of his busy schedule, and we can engage with him directly. Stanley, are you with us? In that case, we'll move to Kirsten and then Rachel, in terms of two key interventions that perhaps you could try and push from your end.
That's quite a big ask. Because
or suggestions. It could be a suggestion as well.
Caught me by surprise. One of the most important things I think we need to do is try and create more awareness. I certainly think as a term, it wasn't a term that we are generally used to. And perhaps maybe it's really an intervention as much as creating more knowledge on the platforms that I can share knowledge on, and with colleagues that I can share knowledge with. That would be my first one. That's my first thought, is that to just give some more, unpack Ecocide and maybe in the South African context and in the work that we do, and start using the word more often or at all. We've never actually used the term in any of our papers, our court papers, in any of our posts on social media, in any of our op-eds or anything like that. The term ecocide has never been used. So I think that would be one thing that I would start doing. Secondly, I would really like to to be more involved in the SADC collaboration. We do work in the SADC region, and there's often been talk about collaboration, and perhaps I'm just not in the loop. But I would certainly, as a representative from All Rise and from the South African context, like to explore pushing the concept of ecocide and the criminalisation of environmental harm in South Africa, but also as in collaboration with the SADC region. On the fly,
Thank you very much. I think that's very important, just getting people to use the word ecocide and the term ecocide and just creating awareness. And from the Secretariat, we'll provide you with some of the tools we have developed to assist you so that you don't have to start writing them from scratch, and that you can, get people to start using the word ecocide and understanding what it intends to achieve. Rachel, I think your interventions were very critical in terms of the actions from the Parliamentary Forum in SADC and what they can do. Just to summarize, two key possible actions, and then we'll pick up the rest offline in terms of progressing this discussion from a discussion into key advocacy.
Thank you, James. Equally, without over-committing and under-delivering, I think my intervention is equally rooted in the opportunities that exist at the SADC Parliamentary Forum, and therein lies the opportunity for sensitization and capacity building for the various committees of the SADC Parliamentary Forum. So I think we could look at capacity building initiatives for parliamentarians through targeted initiatives that look at the intersection of each committee's area of remit, of course, because of the cross-cutting nature of this topic. And I think we can look at interrogating regional dialogues for parliaments to get the requisite political buy-in. And I think in addition, just off the top of my head, when we look at maybe developing a tool that we can then share with these parliamentarians is perhaps conducting a gaps analysis in terms of interrogating the existing SADC protocols and looking at how we can then strengthen their enforcement mechanisms and address the gaps therein to recognize and speak to the question of ecocide.
Thank you very much. I think that was excellent. Given the time constraints that we have and that we're experiencing, and also the quality of the video and audio, I think it's time that we can call it a day and then pick up some of these things offline. There is a question from Fatima Bula Musfaka. As a journalist in Zimbabwe, I think it's a critical aspect to tackle my articles. I would also like to do more coverage on this. Thank you, Fatima. I've got your contacts and I will reach out to you. We actually have a group called Africa Journalists for Ecocide Law that I will include you in. And for the rest, thank you for your input. Thank you for giving us your time and being very committed and enthusiastic. We will follow up and we will adopt this group as our SADC advocacy working group so that we can pursue various elements of getting this dialogue on ecocide law within parliaments, building capacity, raising awareness, and perhaps moving towards the publication of a regional protocol on ecocide law. Thank you very much. I think we've just run out of time. There is so much that we could have discussed, and I think perhaps we will have the opportunity for another forum and another discussion. Thank you very much, everybody. I'd like to close at this point because we've taken 2 hours. I wish we had more time for questions. Please feel free. I'm going to just type my WhatsApp number here so that those who are asking questions can just reach me so that we can connect further. So I have put my WhatsApp number there. I'll just give you a minute to just take it down, and the rest people like Rachel, I can reach through Justice and other people. Thank you very much for attending, and I think it would be very cruel of us to take more of your time, having taken 2 hours of your morning. Thank you very much, and let's catch up in the future with regard to future advocacy. Thank you.